Good morning, everybody.
Good morning, sir. Can you hear me?
Good morning. Right, welcome to everybody to this meeting of the Countryside and Rights of Way panel. It's obviously the 28th of April and a little bit after 10 o'clock. Apologies for that, but people have had a chance to sit down and get their papers together. Could we start, please, with apologies?
Yeah, we've got apologies from Councillor Waring and Councillor Snape.
Thank you. And are we correct?
Yes.
Thank you, members, for attending. And we'll go on to meetings of the meeting held on the 20th of January 2023. Now, if members will bear with me, I have to read out a statement about those members, particularly in regards to item 2, minutes of the last meeting. At the last panel meeting, there are 3 of us in attendance, myself, Mr. Smith and Mr. Abrahams. Item number 49 in the minute refers to an application to upgrade public footpath 35 Ipstones to a bridleway. After detailed discussion and consideration of the legal and documentary evidence was presented, we as members clearly intended to support the application. Unfortunately, when reaching our formal application, we stated our report by saying that we agreed to upgrade the footpath to a bridleway. This was recorded in the draft minutes which were published on the county records, on the County Council's website. The minute was challenged by a member of the public as we do not have the authority to upgrade the bridleway. The correct process for us to agree is to make an order to upgrade the footpath to a bridleway. As we know, a legal process is then instigated from which a final decision on the application is reached. I therefore propose that the decision at minute 49 on the attached be amended to read, and it is that the decision that the information presented by the Director for Corporate Services detailing the legal and historical documentary evidence and the user evidence be acknowledged and is considered to be finally balanced. Taking into account the unexplained presence of bridled gates along the footpath and the absence of any opposition from landowner, the local parish council and the county council for the area to the proposal, the application to upgrade the footpath to a bridleway be supported, and C, that an order to be made to upgrade the footpath C, that an order to be made to upgrade the route of footpath 35 Imstones to a bridleway on the definitive map and the statement of public rights of way. Is there any other points that we need to mention on the minutes of 20th of January? No? David, you were there. You're happy with them now? Thank you very much. So we'll sign the amended minutes after the meeting, please. Okay, this is the point at which my iPad's just switched itself off, so apologies. Okay, on item number 3, declarations of interest in accordance with Standing Order 16.2. You're not... Okay, thank you. Okay, thank you. It was really for our members to make an interest, but thank you for the information. Have we any interest from... No. I haven't got an interest, but I would say that I think there was quite a number of people were copied into a letter before the last meeting should have gone ahead. Claire, do you want to just make a quick comment on that letter?
Yes, thank you. There was a letter received, several members received it and also several officers. The letter didn't actually add anything further that hadn't already been addressed by the by the landowners' legal representatives. So it will hopefully be addressed today within the presentations given, but it's also already within the bundle. It hasn't provided anything new.
Thank you for that. Okay. So we'll move on, please, to item number 4, which is the application for an order under Wildlife and Countryside Act 1981 to modify the definitive map and statement from the addition of a public footpath from Stretton to the highway to the east of Bickford Grange Farm. Now, how we're going to do this, please, is we're going to start with Mr. Webster and keeping to 30 minutes, please. We'll then move to the landowner's representative, again 30 minutes maximum, please. And finally, if the applicant is here, we'll give him the choice, him or her, the choice to comment again for a maximum of 30 minutes. So could we please start with Mr. Webster, who's online? Good morning, everyone, again. Had to relocate to what is now the Stafford room in the building, so enjoy the tour of Stafford Place buildings. We got to the point where we started item 4, and Mr. Webster was going to make his presentation. Mr. Webster, could you just say good morning, just to check the sound?
Good morning, sir. Can you hear me now?
Yes, thank you.
Good, good, good. Shall I kick off, sir, with your permission?
Yes, please.
Right, we've lost time this morning, and I'll endeavour to hasten the process where I can, sir. So, I'm a London barrister, and I was brought into this case soon after judicial review proceedings were brought by Piers Monkton and the Somerford Farm Partnership in October of 2021, and the objective of those proceedings was to have the decision of the panel made on the 16th of July 2021 to add the claim for public footpath to the DMS for the area, to have that decision quashed. Now, that decision has not yet been implemented because of the judicial review proceedings that were heard over 3 days in London, and the judicial review claim was dismissed by order of Mrs. Justice Lang, dated the 1st of December 2022. Permission to appeal that order made by her was subsequently refused by Lord Justice Warby by his order dated the 22nd of February 2023, and those proceedings are now at an end. Now, the case that is to be put today by the objector's counsel, Mr. Dale Harris, who sits on your left, sir, at the end of the table, he appeared as junior counsel to George Lawrence KC at that 3-day hearing before Lang J. And the case that is to be put today, in objection to the order, is the same or virtually identical to the case that was rejected by Mrs. Justice Lang, and it's worthwhile making that point at the outset. So I've done an addendum report, which I may assume that members have read. I'm sorry to say that it runs to as long as 34 pages and is accompanied by a number of additional documents running to 61 pages, for which I apologise, although it may assist you if you go to the enclosed documents and sort of focus your attention on page 2. Page 2 of the enclosed documents is as good. Page 2 it shows the claimed footpath between points A, B, and C. That's to say, the red line. And if it's easier, if you could detach that page from the documents, I don't want you sort of manhandling the bundle too far, but if you have that page 2 to one side for easy reference, then that I think would be very helpful. That footpath links Stretton and the hamlets of Bickford and Whiston in an area sited just to the west of Penkridge, close to the A5. So the claimed public right-of-way crosses land owned by Piers Monckton and his farm partnership, and that of Mr. Monckton's son, who has taken no active part in the case. Now, Mr. Monckton's farming business is based at Home Farm, which is near Streatham, on the outskirts of Streatham, and the claimed public right-of-way runs close to farm buildings as it runs in a northerly direction to point C. Now, so today's meeting is a review of the decision made by the panel on the 16th of July 2021, and it might help if I explain just how it is that we arrive at the situation we're in today. Mrs. Justice Lang invited me to consider at the hearing whether the principle established in the planning law context should be applied by way of analogy to the present statutory context. And that principle is this: it's where an officer is about to issue a decision and becomes aware of new material considerations, he can only safely proceed if he has referred the decision back to the council in order that it might be reconsidered with the application in mind. And because I was loath to subject the council to the risk of a quashing order and an order to quash, I on instructions from officers, readily acceded to her suggestion about this. So the decision today is essentially a review of your decision made in July 2021 in light of, one, the further evidence and submissions which have emerged in the course of the judicial review proceedings, two, the finding of the court in those judicial review proceedings, and thirdly, any later representations or objections received by the council from interested parties. And we have one or two interesting representations made that I'll deal with later. Now, the undertaking, sir, that I gave to the court on behalf of the council requires the panel to conduct its review on the basis of the addendum report and any further representations which I have been made either in writing and or are made orally at the review meeting. And it's obviously a matter for you to decide on the scope of any oral representations that may be made to you, particularly in light of those on the part of the objectors that are supported by written representations that I've read. So it's important to note that today, contrary to what is suggested by the inspectors, the panel is not today starting from scratch, as if its earlier decision had not been made. In other words, we're not today dealing with the thing in a vacuum. The object of the review, sir, is for the panel to consider its original decision on the application in light of new material considerations brought before the panel, in order that it may determine whether its original decision continues to be justified or should be rescinded. It is my recommendation, my firm recommendation to the panel, sir, that the original decision continues to be justified in light of the new evidence, even though the council now accepts that elements of the original officer's report were flawed. And so whilst the panel is not bound to accept my recommendation on how the application today should be proceeded with, I suggest that the panel would still need to demonstrate that proper grounds exist in order to show why my recommendation should not be followed. So I don't know whether you require an outline of the relevant legal framework, although I can give it to you if you choose, but as I don't want to waste excessive time, but you're aware that under the Wildlife and Countryside Act, and I'll give this in the most abbreviated way I can, under the Wildlife and Countryside Act of 1981, the modification order is premised by the discovery of any one of the events mentioned in section 53C, one of which is the discovery of evidence which, when considered with other evidence, shows that a right-of-way not shown on the DMS subsists or is reasonably alleged to subsist over the land in the area to which the map relates. Now, pursuant to Schedule 14 of the 1981 Act, and again I'll abbreviate this, it is the duty of the panel to investigate matters contained in the application, which involves a consideration of the evidence said to justify the inclusion of the claimed part of the DMS. And under the Highways Act of 1980, the panel may take into consideration any map, any plan or history of the locality or other relevant document which is tendered in order to demonstrate whether or not the highway existed at a particular point in time. Now, it's also relevant, and I know I'm teaching this panel to suck eggs, but it's also relevant to remind ourselves that once a public highway has come into existence, it will continue to exist indefinitely. And these rights can only be brought to an end through closure or diversion under a legal order. The maxim is that, as you know, once a highway, always a highway. Now, the council's approach to the new evidence said to justify modification of the DMS, it must be in conformity with the Roxlina case, a decision of the Court of Appeal in 2091, in which it was made plain, and again I'm abbreviating where appropriate, in which it was said that the margin of appreciation at the order-making stage is a generous one, and the council's duty to investigate under Schedule 14 does not require it to investigate a particular matter in greater depth and detail than it reasonably judges to be necessary. And by virtue, and again I'm reminding you of what you already know, by virtue of Schedule 15, Para 7 of the 81 Act, before a modification order can take effect in law, in an opposed case as this is, it must be confirmed by the Secretary of State, who is able to appoint a specialist inspector to hold a public inquiry or to hear representations. So there is a process here, and we're at stage one in that process. It's as well that we remind ourselves about that. It follows from all this that the panel is required to do no more than make a reasonable judgment on the basis of the evidence placed before it. And it is certainly not the duty of the panel today to preempt or to prejudge any decision which may be made by an inspector in due course at a confirmation inquiry. So can I just give you an overview of the judicial review claim? It ultimately fails because the objector was unable to overcome the principle that judicial review is a remedy of last resort, and the jurisdiction will not normally be exercised where alternative remedies are available and have not been exhausted. And the remedies in this case are, of course, the confirmation inquiry and the statutory remedy of a right of challenge to the High Court even after we've had our confirmation inquiry. So there are two possibilities there for challenging the order made at the order making stage. And if I could again cut to the chase, as it were, the original officer's report, and this is perhaps worthy of note, the original officer's report, and it was made in March, dated 21st of March 2021, recommended that the modification order was justified on the basis of the evidence of orders made by the Justices of the Peace in 1827 and by Quarter Sessions under the 1773 and 1815 Highways Acts, which included provision for stopping up, which it was claimed by the officer's report supported the claimed footpath between points B, C on the plan at page 2, to which I've already referred. Secondly, the Finance Act material of the 1910, which it was claimed supported the claim path between point BC on the plan at P2. Again, I've referred to that. And also, thirdly, the Penkridge Parish survey records that predated the definitive map and statement, which it was claimed also supported the path between points BC. Now, the officer's report was before you, and you accepted the recommendation, and there then followed judicial review proceedings. Now, in my report, I identify that after the order was made, the objectors instructed Michael Rocks, an experienced chartered land surveyor, to provide mapping evidence, and also instructed was a Robin Carr, who provides consultancy services in relation to public rights of way. And he also provided a report, which he revised on the 11th of May 2022. These two reports, sir, and the documents and plans that accompanied it, filled a lever arch file in the judicial review claim and ran to a total of 270 pages. And obviously, the panel does not have all that material before it, but it was a vast quantity of paperwork that had to be absorbed and digested and considered by the council. And in response to that expert evidence of Messrs. Rocks and Carr, the council instructed Shona Frost to provide expert evidence on behalf of the council. Now, Shona Frost is an important player in this case because she is employed by the council as a team leader in their spatial mapping team, which comprises a part of the council's Communities and Families Directorate. Now, Shona Frost, who is, I might add, an army-trained cartographer, is a fellow of the Royal Geographic Society and a chartered geographer, and is also a member of the British Cartographic Society. And it was very helpful having her because she generated a number of plans that were extremely useful in the judicial review proceedings. She put in two witness statements, and the plan at page 2, to which I've already referred you to, was a considerable point of useful reference in the judicial review proceedings. On that plan at page 2, in my that is attached to my addendum, she identifies all the points that were relevant in the case. The documentary and other evidence now relied on to justify the making of a modification order, sir, are well and truly set out in my addendum report. So I don't want to go through them if I can avoid doing so, but I'm dealing with the orders of the orders made by the Justice of the Peace in 1827 and by quarter sessions that determined an appeal against those orders by the JPs. And I've attached to my addendum, sir, the documents that I've, as it were, filleted from all the files that are truly of relevance in the current context. And what it has emerged, and what emerged as a result of the intervention by experts instructed by the objector, is that there was a gap on the plan between points B, P1 and B1. So this was not considered last time and was only discovered by the intervention of experts instructed by the objector. So what we had was an unmapped gap of 300 to 440 meters identified between points B, P1 and B1 on the map at page 2. Now, if I can sort of, in a nutshell, say how we overcame that, the council has a responsibility to investigate these matters, and it did. But the view of Shona Frost is that although that gap was simply not there was no map between 1827 when we come to the map in relation to the orders made by the JPs in 1827 and 1828. And 1880, when we had the first ordnance survey map for the area, although we don't have any mapping evidence for that period to explain the alignment taken by the red line on P2 between points B, P1 and B1, it was the very strong view of Shona that alignment could be justified on the basis of the likely alignment of a path that ran all the way between Stretton and the hamlets of Bickford and Whiston that were identified on the 1827 plan that you will have seen, because it's all there for you to see. And so the view taken was that although there was an unmapped gap of 300 meters to 340 meters between points B and B1, it was probable that the alignment was as shown and was identifiable by reference to the Ordnance Survey map in 1880, because the survey that would have predated the making up of that plan would have identified that there was a track in existence between those points, and there was no real probability that the alignment was anywhere else other than where shown on the 1880 plan, and that there had been no, as it were, occurrence on the land or any sort of development or change in the layout of the fields that would have given a reason as to why the layout shown or the alignment shown would have been any different than that is shown plotted on page 2. So Shona Frost dealt with that in her evidence, and in my view, her case about that is highly probable to be the case. I can say this. She said this, and I'm reading from my note. It is a view of Miss Frost that the footpath lines shown on the OS maps in the context of open countryside do not, without an obvious reason, usually alter their alignment. Development or radical revisions in field layout might be reasons for this, but as far as she can judge, nothing of the kind has occurred in this instance between points B, P1 and B1. So that, I repeat, the unmapped gap between points B, P1 and B1 is explained in the expert evidence of Shona Frost, whose view it is that the alignment shown in the 1880 Ordnance Survey map is more than likely to have replicated itself in the period after 1827 and is unlikely to have been in any different place. The Finance Act materials, I suggest, it demonstrates beyond any doubt that a footpath exists between points B1 and C on the map at page 2, and I'm not aware of any compelling evidence that would suggest that the objectors are correct in their assertion that no footpath can be demonstrated between points B1 and C. So the third issue was the reliance on the Penkridge Parish Survey records. The council no longer relies on those records. And the points made by the objectors about them are no longer material. There was one interesting point of law that arose from the provisional map that predated the initial definitive map and statement, and that concerns a declaration made by Staffordshire Quarter Sessions in 1965. I won't go into detail on that, but as a matter of law, the view taken by Mrs. Justice Lang was that that declaration made by Quarter Sessions in the context of a right of challenge arising in the 1949 Act is of no consequence in modern times, and that the 1981 Act superseded in its entirety the statutory scheme arising under the 1949 Act. And I lay out in the addendum the findings of Mrs. Justice Lang. There were 9 grounds of appeal, and she dealt with each one of them, and they were all rejected by her. And I don't want to waste time now going into them, because I don't think it really serves any useful purpose now, other than to say what's in my report, and it's available for you to consider as you choose. The application for permission to appeal to the Court of Appeal needs to be looked at. The decision of Lord Justice Warby on the objector's application for permission to appeal to the Court of Appeal will also be found at pages 51 to 52 in my enclosed paperwork. As already indicated, so the objector was claiming that Mrs. Justice Lang was wrong in finding, in effect, that the 1965 declaration under the 1949 Act did not survive the repeal by the 81 Act. It follows from her admittedly preliminary ruling that the declaration made by Stafford Recorder Sessions on the 5th of November 1965 did not have the effect mentioned in section 31(8) of that Act, which would have been to render such declaration conclusive. As I say, the statutory regime changed. The Wildlife and Countryside Act now governs the creation and organisation and management of public rights of way, and you need have no concern now about the 1949 Act. Although it is true to say that Lord Justice Wilby said that there were interesting points and that the issue might go one way or the other. But I think there are, and I'm running on, I admit, perhaps 100 miles an hour, certainly quicker than I would have done than if I'd been before a judge. But we have had some representations made since the hearing in the High Court. The Area Footpath Secretary of Staffordshire Ramblers wrote to the Council on the 22nd of February 2023, saying that she had been contacted by the Ramblers District Footpath Secretary, who is against the claimed footpath being added to the definitive map and statement for the area. Her letter noted that the proposed footpath, and I quote, is not used by locals. It is a contrived path that finishes on a very busy road with no pavement, and it passes through home farms. Connecting point C via point B to footpath Penkridge 43 at PO2 will be much more beneficial. Perhaps more importantly, so on the 21st of February 2023, the Parish Council Manager for Lapley, Stretton and Wheaton Ashton Parish Council wrote to the council saying that the parish, and I quote, would like to reiterate that they retain the view that the footpath should be added to the definitive map. So the objectors have put in what is described as a comments on addendum report in a document settled by council on the 1st of March 23, which is before members. They maintain, as I've already said, their objection to the proposed modification orders on the same grounds which failed before Mrs. Justice Lang. So dealing with some of the objectors' points, and don't worry, I'm coming to the end. Firstly, the objectors' observations in relation to the 1827/1828 orders, the Finance Act 1910 material and the Penkridge Parish Survey reports are all dealt with in the extract taken from Mrs. Justice Lang's judgment, and I've set that out in extenso in my report, and it is unnecessary to replay these matters today. They failed. That's my point. Next, the case for a modification order is as summarised in my addendum report, and it is for the panel to come to its own conclusions about the evidence and whether it can be said to support a decision that the claimed footpath can reasonably be alleged to subsist between points A, B, and C on Planet P2 attached to my report. So the council accepts that various aspects of the way in which the evidence was presented to the panel on the 16th of July 2021 can no longer be maintained. All these matters so were put to Mrs. Justice Lang, whose view it was that they did not justify a compelling need for the court to intervene by way of judicial review to quash the decision of the panel. The council recognises, sir, that the initial report contained flaws, none of which, in my opinion, are likely to be sufficient to make any difference to the soundness of the existing decision in view of the way in which the council now puts its case. For instance, the gap between points B, P1, B1 is admitted and is now plausibly, as I say, explained in the new evidence as shown of Frost, and will obviously involve fact-finding and resolving disputed interpretation of maps, which are better suited to a determination before a specialist inspector and a public inquiry that will probably, at this rate, take about a week. So the objective contend that the panel, and this is important, must determine afresh whether it considers that a public right-of-way can reasonably be alleged to subsist over the claimed path as a whole. I don't accept, and I don't think as a matter of law, you are required to, as it were, start again from scratch. The process envisaged by the undertaking which I gave on behalf of the council to Mrs. Justice Lang is that the council should review its previous decision in light of the further evidence and submissions made in the course of the judicial review proceedings, and of course, along with the findings of the court and any later representations or objections. It is not a rehearing, sir, but a review. In the writer's view, it would not be in the interest of good administration for the panel to be invited, in effect, to second guess the outcome before a specialist inspector at a confirmation inquiry. The reality is, sir, that since the matter has been, since the order that was made, the 3 experts have looked into this application since July of 2021. The work and effort put into this matter by competent expert evidence on both sides, it makes it neither sensible or practical, in my view, for this panel at this review hearing to inquire in detail into matters which will be dealt with by an inspector in the course of the statutory process. The only decision for the panel is to decide whether it is reasonable to allege that the claimed footpath subsists or is reasonably alleged to subsist in the circumstances where the council's duty does not, as a matter of law, require it to investigate matters in greater depth and detail than it reasonably judges to be necessary. It is, in the view of the objector, it is the view of the objector, as I said, that the panel should take into account that there is no direct evidence of actual use, and that this, and I quote, weighs heavily against the overall inference that a public right-of-way subsists over the claimed footpath. So in my view, so that's a very bad point, as the application to include the footpath between points A, B and C is based on the older documents and not on modern-day user sufficient to support an inference of dedication. The panel obviously has ample experience of such cases. Reference should be made to what has already been said about the rule that once a highway, always a highway, and a highway, once it exists, can only be removed by dint of a legal order, such as a stopping up order or a diversion order. The Objectors' Council, sir, deals with, at some length with the Penkridge Parish survey records on which the council no longer relies. The relevance of much of this is now questionable anyway, now that Lang J has found that the focus should be on why and on what basis the footpath between C, B1, P1 and P2 was included on the provisional map in the first place, and that should be clearly looked at and will be looked at a confirmation inquiry. The council accepted at that stage in 1965 that there was no public footpath between those points, and the council is now arguing the contrary in the light of the evidence that has been found, not least the expert evidence of Shona Frost. So lastly, the Objectors' Council challenges the inclusion of the Finance Act 1910 material. One of the friends suggests that there is another footpath within the Hereditament 610 land, which also crosses 3 fields shown on the OS mapping between points P, Q, R, T, U. This is another bad point that was clearly rejected on the basis of the analysis of this matter by Shona Frost in her analysis, and the plan that she generated that deals with this again is within my report. My conclusion, sir, and I know you want me to come to the point, can be expressed quite shortly. The Objectors' Council is obviously right when he says that the evaluation of the evidence is for the panel and not its advisors. The panel needs scarcely be, as I say, reminded about this. It is appropriate that I offer my advice about this to the panel on the approach which they should adopt to the evidence which is now before it. Clearly, sir, the panel must reach its own conclusion on the weight which should be attached to the fact that the objectors failed to persuade the court, the High Court, in a 3-day hearing to quash the panel's previous decision. So both Mrs. Justice Lang and Lord Justice Warby took the view that it would be appropriate now for the disputed factual issues to be resolved by an inspector appointed by the Secretary of State under the process for this laid down in Schedule 15.7 to the 1981 Act, which obliges the council now to submit the opposed order to the Secretary of State for confirmation by him at an inquiry held by a specialist inspector, who would also be able to determine, as will be the case, the objector's point of law under the 1949 Act with the assistance of counsel. It is, I think, certainly arguable that the approach of the court in this case, the dismissals at the High Court level and the rejection of the application for permission to appeal, I think it implies very clearly, in my view, that the order made by the panel can still be justified on the basis of the evidence which is now available to the parties. In other words, that it would be open to the panel, I suggest today, to confirm its previous finding that a public right-of-way can reasonably be alleged to exist between points A, B, and C on the plan at page 2 of my addendum report. So neither judge, sir, criticised the act.
Mr. Webster, could you wrap up now? You've gone over your 30 minutes.
I do apologise, sir. So neither judge, and yes, I will wrap it up and I'll say these 2 points. Neither judge criticised the actual decision of the council, nor found that it disclosed any serious and obvious errors of law which would have given rise to a compelling need for the court to intervene by way of judicial review. I need to reiterate that the modification order is only the first stage in a link in what will be in this case, likely as not, a lengthy legal process which now moves on to the confirmation stage. As I say, there's a wide margin of appreciation in this matter, and the council does not have to descend into the detail other than to decide whether or not it reasonably considers the claimed way to be, as it were, to exist on the evidence. I consider, sir, that it would be reasonable for the panel to find on the evidence, as summarised in my addendum report, that the claim footpath is one that does exist, and that its addition to the definitive act will be justified. So if the panel decides to take this course today, the order should be drawn up, and the publicity provisions for orders contained in para 3 to Schedule 15 of the 81 Act should be followed. Schedule 4 of the Wildlife and Countryside Act, definitive maps and statements regulations 1993, must also be followed. This schedule, sir, contains additional provisions in relation to the making, submission and confirmation of modification orders. Of particular interest is the regulation which requires the council to provide a statement of grounds on which it considers that the order should be confirmed. And I would suggest that you suggest that the orders, that the reason why the order should be confirmed after the reasons set out in my addendum report. The council must also provide its observations on any representations which have been made, and I know that officers are well aware of their duties under these regulations. So there I end. I have nothing further to add, although I will ask questions if I am asked any.
Yeah, thank you, Mr. Webster. You did slightly go over, so I think we ought to allow the
with apologies,
applicant's representation to do the same. Would you like to introduce yourself and start your report?
Good morning, Chairman. Good morning, members of the panel. My name is Matthew Dale Harris, as Mr. Webster, but I'm a barrister instructed by the objectors in this matter. I've got a speaking note in addition to the comments, which I know you'll already read in the bundle. Hopefully this focuses, I think, on what are the key issues that the objectors want to bring to your attention today. In my submission, the panel has been put in an impossible situation by the way that the matter's been handled to date. To understand that, I want to first begin by just summarising in quite brief terms what we now basically agreed between the objectors and the council as to the evidential and legal basis of the first decision that was made. And then I'm going to turn to two key issues which, in my submission, show why the advice that you're getting puts you in this difficult position. So firstly, paragraph 2 of my speaking note. I'm the author of the previous report in 2021, tried her best to analyse the issue impartially. She nevertheless made a number of serious mistakes, which include the following. first 3 points that relate to the 1827-1828 material, which I know you've had a chance to have a look at. The first mistake is that she didn't consider the actual terms of the 1815 Highway Act, which was the act which conferred the powers on the justices who were making the order which is contained in those documents, the orders. She didn't therefore consider the fact that the 1827 justices had no power, and this is agreed, this is something Mr. Webster agreed in the High Court proceedings, had no power to stop up a public vehicular highway whilst retaining just the rights on foot. That's something that can be done under the modern legislation, but it couldn't be done under the 1815 legislation. Secondly, she failed to appreciate that the 1827 justices had no power of any sort to determine the status of the path between K1, A1 and K3B. So that perhaps if you turn up page 88 of the bundle, which I think is Mr. Webster's page 37, so it's the 1827. I've got some pagination to page 88. I don't know if you have that as well. Abraham's, I think, has the right page. So it's if you look at the plan, which is page 88. If you don't have 88. 38. 37 on Mr. Webster's pagination. The path marked K is, you see, going from the sort of east side of Streatham up to the north towards Bigford and Wiston, which is the annotation at the top. The author of the previous report failed to appreciate that the 1827 justices had no power to determine the nature of that path, so no power to determine whether it was public or private. Third point, the 1827 order expressly reserved a footpath between A and K1, A1. That's between the point marked C on that plan. You see where the C is, and the first K, so C, B, K. That the 1827 order reserved footpath, but that reservation was obviously deliberately, says the objectors, not repeated in the 1828 confirmatory order. So the author failed to engage with why the 1828 order, confirmatory order, which gave effect to stopping up, didn't contain that reservation. Fourthly, in relation to the parish survey records, she failed to appreciate that the definitive map and statements process in the 1950s didn't support in any way the making of the proposed order. Fifth, she misunderstood, and of course unintentionally, badly misrepresented the effect of the Finance Act process. Sixth, those who were assisting the author of the report with the mapping evidently thought that the Finance Act material extended as far south as point B, but it did not. This is the gap. It extended only as far as B1. Seventh, nobody knows where the path went north of point B in 1827, as the author of the March 2021 report acknowledged when she said at paragraph 63, officers contend that the quarter session order of 1827 does not support the whole of the route, only A to B. If the author had noticed the existence of the gap between B and B1, she would have advised against making the order. And it's clear in my submission that Miss Frost agrees, and I'll come to that further in more detail below. On her evidence as an expert cartographer, it is impossible to say that there is likely to have been a continuous footpath running between points B to P1 to B1 in the period 1827 and 1888, responding there to Mr. Webster's rhetorical question. Eighth, the author also failed to consider, as she could and should have done so, that not only did the definitive map process in the 1950s in no way support the making of the order, she also failed to appreciate that on the 5th of November 1965, a section of the claimed path between C to P1, so a section in the middle there, was declared by the Court of Quarter Sessions to have no public rights over it. Now, I began by saying that you've been put in an impossible position. That's because you have not been advised for the purposes of today in an impartial way, with the errors being explained and with a balanced discussion of their implications. The same advocate who acted for the council on the judicial review proceedings has instead continued wearing his advocate's hat to make the case for making the order. I noted that in his oral presentation this morning, he talked about how we overcame the absence of the gap. The council is not in a position where it is required to overcome anything. If anyone, that's for anyone, that's for the applicant. The council is here required to make an impartial assessment of the evidence before it and discharge its statutory function in that regard. That approach by Mr. Webster has led him to give you some very bad advice, and I'll illustrate what I mean by reference to two of the key issues in this case. First, the gap, and then secondly, the 1965 declaration by Court of Quarter Sessions. So in relation to the gap, we've already had a look at the 1827 plan, and I think the panel will be familiar with it. Note that in 1827, the only things we can know with certainty are, one, that there was a physical path capable of taking pedestrians, which started at that southernmost quay and continued up to the northernmost quay. A physical path, the point being not a path in relation to which we know anything about the rights, and that path continued northwards to the settlements of Bickford and Wiston along an unknown alignment. You can see at the top of the plan the words to Bickford and Wiston. You also know that by 1880, some 50 years later, there was a path, again just a path on the ground, running northward from B to point B1 along the route of the claimed path. You also know that 22 years later, so 22 years after 1880, the same path was shown in the same position on the 1902 OS map. Now, Miss Frost has advised that it's a reasonable inference going forwards from 1880 that the alignment on the path between B and B1, as shown on the 1880 map, remained unchanged. She's done so on the perfectly reasonable basis that the path shown on the 1902 map is on the same position. You have two maps and two dates. She says there's a reasonable inference that it didn't change alignment during that 22-year period. So she says at her paragraph 23 of her report, unless there's any evidence to suggest otherwise, it's reasonable to allege the alignment in 1880 stayed the same over the next 22 years, and we agree. However, crucially, what she does not say is that the reverse is true. In other words, what she does not say is that going backwards from 1880, so into a period for which we have no mapping of this path to the north of point K3, the route of the path as shown on the 1888 map probably remained the same throughout that period. Now, how could she possibly say that? All she does say, paragraph 29 of her second report, is that it is my opinion that there was in all probability a track on the ground between points B to B1, otherwise the OS surveyor would not have noted it on the circa 1880 map. So there was a track on the ground in 1880, is what she says. And as an expert, I need go no further than this. Now, it's obviously possible that the 1827 path went northward from K3B along a route which in 1827 was the same as the route shown 50 years later on the 1880 map. And possible that throughout the 50-year period, the alignments stay the same. But Miss Frost does not even say this, for the very good reason we submit is that there is no evidence whatsoever to support that possibility. Now, that has not prevented Mr. Webster from advising you in his addendum report, and then again orally today, that that possibility is enough to justify you in now making an order which shows a route on the alignment between B and B1, for which the only evidential justification is that in 1827 it was known that there was a path going northwards towards Bickford and Wiston. That's the only justification. We know there was a path, but we just don't know where it went. However, as submitted above, this 1827 path proceeded along a wholly unknown alignment once it goes past point B. Secondly, there is no evidence at all that the 1827 path at that time even went via point B1. So there's nothing to take it to point B1. And indeed, there's no evidence at all that in 1827, the path continued beyond B1 to C. So along the rest of the route that's being claimed, there's nothing to say where it went. The advice that Mr. Webster has given is thus totally at variance with the very cautious advice, the very limited advice given by Miss Frost herself. Mr. Webster's advice is that it's reasonable to allege, that being the test, that there was a path in 1827 along an alignment which is not supported by Miss Frost herself on the basis of a rhetorical question posed by him at paragraph 72. And the question reads, if the footpath running between points B to P1 to B to P1 to B1 did not follow the alignment shown on the green line, the claimed route, then where else would it have run? Mr. Webster goes on to claim that the gap across those points is now plausibly explained in the new evidence of Miss Frost, and will obviously involve fact-finding, resolving disputed interpretation of maps. That too, though, is simply wrong. There are no maps prior to 1880 which enable the alignment of the 1827 path going north to Bickford from Wiston from point B to be ascertained, as Miss Frost herself acknowledges. The author of the previous report, tellingly, in my submission, did not rely on the 1827 map. She had that material before her. You had that material before you, but did not rely on that map and order as supporting the claim path beyond point B, to the point when the map gives out. She said explicitly that the material only supported the claim path as far as B. Ms. Frost has not advised that the author of the previous report was wrong to give that advice. On the contrary, as mentioned above, it's quite clear that the author of the previous report did not believe, and said so explicitly in her report, that the 1827 material reasonably supported the claim path north of B. Ms. Frost has not said that she disagrees with that, and yet Mr. Webster advises you now that Ms. Frost's advice enables you to rely on that material as supporting that route. It does nothing of the sort. If Ms. Frost had disagreed with the conclusion in the previous report, paragraph 63, she would have said so and explained why. And yet, Mr. Webster asks you to put a construction on her advice, which it does not bear, and does so, moreover, without reminding you that if you accept his advice, you will be going against the advice set out in the report of March 2021. Advice which you then accepted and which Miss Frost's evidence does not countermand. It is, my submission, plainly not reasonable to allege that there was in 1827 a path between those 2 points on the alignment of the claim path, for which alignment there is no evidential basis whatsoever. That by itself is a decisive reason for refusing on this review to resolve to make an order. So that's my first major point. Second relates to the events of 1965 and proceeding. And before this application reached the High Court, Mr. Webster and Mr. Lawrence, King's Counsel, who was my leader in the High Court proceedings, reached agreement on a number of matters. One of those matters of agreement concerned the declaration made on the 5th of November 1965 under the 1949 Act. At that point, the declaration had been made, but Mr. Webster and Mr. Lawrence agreed that there must have been such a declaration and that the path between points C and P1 shown on the provisional map had been removed from the definitive map and statement as a result of that declaration. The declaration itself was subsequently found and is in your papers, so I think you will have seen it. Its effect on the clear terms of the statute in 1949 was to make it conclusive that there were no rights of way between point C and point P1. The landowner at that time had no need or right, in fact, to seek a declaration south of P1 to B and A, because the provisional map at that point didn't show any right of way at all down to those points. So there was nothing to make an application in respect of. The conclusiveness of that declaration could not be undone by the later discovery of evidence which predated the relevant date of 1954. That was the effect of the 1949 Act. The then owner, having got his declaration, was free thereafter to build a house or a farm building, whatever he wanted, on the land to which the declaration related, in this case across the path between 2 and 1, knowing that because of the declaration by a court, nobody could later come forward with historic evidence proving that there was, after all, a right of way between those points. And to illustrate that, I'd invite you, for the purposes of what follows, to imagine that such a house had been built in 1971. I also ask you to assume, contrary to our case, so just for the purposes of understanding what the position is before this panel, assume that, contrary to our case, none of the evidence that you're now being asked to rely upon had been before the quarter sessions in 1965. So they hadn't had the 1827 material, they hadn't had the Finance Act material. Now, Mr. Webster seeks to argue that the enactment of the 1981 Act, the Wildlife and Countryside Act's relevant provisions, have undone the conclusivity of the 1949 Act provisions and of the declaration made under it. That's effectively his position. We say, the objectors say, that that's wrong as a matter of law. Lord Justice Warby, refusing permission, said the point hadn't been decided and there were powerful points either way, effectively. So it's an open question of law. There isn't authority on it. Now, no doubt it will go to court at some point, either in this case or another. But the key thing to recognise is that the panel needs to decide what it thinks of the law now, because that will determine whether an allegation can reasonably be made as to the subsistence of the path or not. If you think Mr. Webster is right on the declaration point, then the declaration of 1965 stopped being conclusive when the 1981 Act came to force. It just simply stopped. That effect wasn't worth the paper it was printed on. Even though that imaginary house had been built in the past 50 years, the public will have the right in this assumed world to walk straight through the drawing room, because the right of way, once a highway, always a highway, and there's no declaration to rely upon. Now, that's the effect of Mr. Webster's construction of the statute. If you think we're right, there will be no rights across that stretch because we have the declaration, and our house would be safe. Moreover, as the climb path would now end with a nonsensical cul-de-sac at point P1, and the rest of the claim path would also have to be rejected. Now, I noted that when Mr. Webster was giving his summary earlier, he said this is something he didn't want to go into, this legal analysis. But in my submission, that does this panel a grave disservice. You cannot duck this matter by saying that it raises a new point of law, which could go either way. Because to take that course, I'm at paragraph 14 of my oral submissions, and to take that course would be a dereliction of your duty to decide whether or not a footpath, a right-of-way, can be reasonably alleged to subsist. You can test it this way, because of course, suppose you were of the view that the landowner is right, i.e. that despite the 81 Act, the declaration remains conclusive. In those circumstances, it would obviously be wholly wrong to make an allegation. You couldn't reasonably make an allegation that that right-of-way subsisted, because the declaration tells you on its face that it doesn't. That's not a question of second-guessing what the inspector may or may not decide, or indeed second-guessing what the High Court might decide in due course. The panel must discharge its own duties now. And of course, it's not, in that matrix, it's not as if there might be some hitherto undiscovered evidence which could make a difference to the legal point. I asked you to imagine that all the evidence is assumed against us. It's assumed that in 1965, the council didn't dispute the issue, didn't look into the matter, didn't find the 1827 material, didn't look at the Finance Act material. So we're assuming that all of the points that can really be made about the declaration are against us. And supposing even further, which we of course completely deny, that the material shows that the declaration should not have been granted, we say, as a matter of law, that that will make no difference. The declaration is made, it hasn't been challenged by court, it's effective, it's been relied upon. The whole point of the declaration procedure was to put the council to proof on behalf of the public. And so the legal point doesn't matter, it doesn't depend on what evidence may come forward in the future. On that basis, it's as if the landowner was saying to the council in 1965, if there's any evidence in your archives or anywhere else which you think shows that there is a right of way and which would justify having a path between P1 and C, now is your opportunity to produce it. If you don't or can't find any such evidence or don't bother to look, and you therefore don't produce it, that makes no difference at all, because I, as a landowner, will obtain my declaration, the Republic rights from C to P1, and that will thereafter be conclusive that there are no such rights. It will be no good you're coming along at some point in the future with evidence of which you knew nothing and claiming that that justifies. And that is the balance that Parliament struck in creating this procedure of applying to court. This is therefore a point that you have to decide now. There's no evidence that might come up that could weaken the effect of the declaration my client's predecessor obtained in 1965. If you think my client's legal point is right, it cannot be reasonable to allege that there's a path. The conclusivity of the declaration of non-existence makes such an allegation inevitably untrue, and therefore makes it not reasonable to allege that there is such a path. Mr. Webster has advised you to the contrary. He accepts that there is a potentially decisive legal point that could be decided in two senses, or shall I call Q and R. If Q is right, it means that the 1827 and Finance Act material is admissible. If R is right, it means that the material is not admissible because the 1965 declaration remains conclusive despite the 1981 Act. But having accepted that there is a decision to be made between Q and R, Mr. Webster then wrongly advises you that you're free to duck it. Because on the basis that, because for all you know, some evidence may be found, relevant evidence may be found to the inquiry. Now, that's an impossible submission, as I've sought to demonstrate, because we've asked you to assume everything against us in terms of what might come forward at the inquiry. There is, however, nothing whatever to suggest that the physical route to which the declaration applied might be a different route than that represented by the council itself running north of Point C. Now, a point just about the wider context here. Many such declarations under the 1949 Act by the Court of Sessions, were applied for in Staffordshire. For all we know, many landowners subsequently built their houses across paths which had been declared not to exist. No doubt, in some or even quite a few of those cases, evidence existed at the time which, had it been produced, would have meant that declarations in those cases would have been refused. That's the nature of any process, particularly one that happens under pressure, as was the situation in the 60s and 50s when they were dealing with the first definitive maps. There are, moreover, many people, such as the applicant, who spend time unearthing historic evidence from the council's archives. Such evidence can sometimes prove that there was once an old public right-of-way that has never subsequently been stopped up, so far as anyone knows. If the effect of the 1981 Act was as Mr. Webster contends, there are therefore bound to be similar cases as this one in the future. The fact that there haven't been such cases must be because nobody has previously sought to argue that the 1981 Act, whose operative reasonably alleged to subsist provision is, in our submissions, materially identical to what existed in the 1949 Act, had any such effect. The council must therefore decide the legal point that arises in this case in order to decide whether a right-of-way reasonably alleged to subsist. Accordingly, that's what you should do in this case, we say. But obviously not until you first considered the point in detail, so that you can decide it properly. What you can't do is duck deciding by acting on Mr. Webster's advice that it should all be left to the inquiry. His advice amounts to saying that because the point could go either way, it is meantime reasonable to allege that public rights subsist. And that being so, the council is entitled and bound to make the order. That is, in my submission, unsustainable. If the council acts on Mr. Webster's advice and an order is made, my clients will object. They will try to persuade the inspector not to confirm the order, and one of the points taken will be this legal point. We expect the point to succeed. If it does, the objectors will also submit that the order should never have been made because had the council acted properly, it would have ensured it had been given proper, balanced legal advice on the merits of the point, either way, the merits of the point, and would in consequence have been able to decide the point properly. Instead, it allowed itself to be deflected, or it might allow itself to be deflected from deciding the point by the erroneous advice that new evidence might perhaps be found between now and the public inquiry, which could make a difference. Neither party has ever suggested that the legal point outcome depends on whether the route shown on the provisional map really did run between C and P1. My clients would submit that to make an order in such circumstances was unreasonable behaviour, meriting an award of costs against the council. Mr. Webster is also wrong to say that the council is not starting again. The answer is that by having to decide the matter, that's effectively what it is required by its undertaking to do. It obviously can take account of the previous report, but as accepted, that report contains very substantial flaws. Moreover, what it needs, in my submission, is wholly independent advice from another barrister and not from someone who has previously acted as its advocate, in order to properly carry out that quasi-judicial function of deciding whether it is reasonable to make an order, bearing in mind the powerful arguments, factual and legal, for not doing so. And just on a very final point, sir, and I'm aware I may be over my time, that a point was made, my learned friend's oral submissions and also in his written notes, about the significance of the fact that the High Court and then the Court of Appeal rejected the first judicial review proceedings. Now, of course, as you'll have seen from the decision set out, what the claimant, in that case my client, the objectors, had to establish was a compelling reason for the court to intervene at that stage. Now, the court rejected that claim, found against us, on the basis that there was no serious demonstrable error of law. It didn't find that the panel's view of the evidence was correct, and that was not the court's function the first time round. It leaves open the question of whether or not the evidence is sufficient to give rise to a reasonable allegation as to the subsistence of public rights of way. And that matter remains for you in the light of the submissions you've heard and the evidence before you. Those are my submissions. Obviously, if there are any questions, please happy to take them. Thank you, Chair.
Thank you, Matthew. What I'm going to do now is just read out the recommendation so that we all know what we are actually deciding on. And the recommendation is that after reviewing all available evidence and the addendum to the report, to confirm the panel's decision made on the 16th of July 2021, that the evidence submitted by the applicant is sufficient to show that the alleged path is reasonably alleged to subsist as shown running between A, B and C on the plan at page 2 of the bundle of documents attached to the addendum report and should be added to the definitive map and the statement of public rights of way as such. And point B, an order should be made to add a public footpath from Stretton to the highway to the east of Beckford Grange Farm as shown, running between the points A, B and C on the plan at page 2 of the bundle of documents attached to the addendum report to the definitive map. And the statements of public rights of way for the district of South Staffordshire. Now, just for complete clarification, this is, as far as I understand, to confirm the panel's decision on the 16th of July, not to go into a lot of legal discussions, which I don't think is this panel's remit. Could the officers please confirm what will happen if we follow the recommendation in front of us? What will be the next stage, or what could be the next stages?
If you confirm the decision that was made in July 2021, which is our recommendation to make the order, we will then add that order to our list of orders to be made, and we will follow the normal process that we would normally follow with these type of matters.
And what is that process?
So that would be to make an order, we would get that sealed, it would be advertised, people would have a chance to object to that order. If objections are received, it will then go to the Secretary of State for a decision. Right.
Now, in fairness to what's just been said, would the legal points that have been brought up, which are bigger than this case, be discussed at that juncture?
If the objections that are made refer to these legal points, and obviously that's something that will come at a later time, then those objections would be passed to the Secretary of State to deal with, and they would deal with it by way of a public inquiry or written representation, but it would be for the Secretary of State to deal with that process at that point. So any objections can be made to an order, and those objections just get forwarded to the Secretary of State.
Okay, thank you for that. I hope does that clarify slightly for members? Okay, have we any questions from members? No? Have we any proposition from members?
I move the recommendation, Chairman.
I'll second. So we've got a recommendation to accept the officer's recommendation. Could we vote on it, please? In favour? And there's obviously there's no one against it. So majority decision. Or can I thank both of our extremely good orators for their time, and apologise for the technical problems we've had forwards. So in conclusion, we are following the officer's recommendation on this. Thank you very much for your time.
Thank you, sir.
Chairman, just on the basis of whatever future action may come about, should we hold on to it?
Wait, yeah. And I think my final point is we close the meeting at 12:12. Thank you very much.
Thank you.